we're moving to a Zoom call where we have lawyer Suri Sengbe Marrah. He's a human rights activist and lawyer who yesterday won a Supreme Court matter against the Inspector General of Police on the Elections Day Vehicular movement ban that was slammed in 2018. We have him now to talk on this and his reaction to the Supreme Court's ruling. Good morning, Augustine, and welcome to the show. Yesterday, after 4 years, in 2018, you took that matter to the Supreme Court on the ban of vehicular movement on Elections Day, and yesterday a ruling was given. What's your reaction to this? After this long, the Supreme Court judges said it's unconstitutional, especially when it was not sanctioned by the House of Parliament.
I think generally, the judgment came just at the right time. Personally, I feel extremely excited because it's very difficult to litigate in the Supreme Court for obvious reasons. One, if you lose a matter in the Supreme Court, you stand the risk of very high cost that can be ordered against you. But I think personally and nationally speaking, this is very monumental for the governance in Sierra Leone. We talk a lot about, increasing the space for citizens' engagement in politics, etc., etc. And so in 2018, what I sought to do was to hold public authority to account, in that if there's a specific legislation that provides for the banning of vehicles or the lack thereof, it does not lie in the lips of one person, to pass a decree. I call it a decree because it was not approved by Parliament. And so in 2018, my decision to litigate this matter in the Supreme Court was born out of a desire to ensure that we grow the governance and to ensure that public officers do not take the law into their hands and convert themselves into the House of Parliament. And so I don't think it's something that has been done before, to bring the Inspector General of Police to court, to get the Supreme Court to make those pronouncements. But I think generally, it's very significant. I'm not saying this is the answer to all our governance problems, but I'm saying this is a very significant step that the court has taken, and which would embolden other citizens to come forward, to take leadership, to take public officers to account, and to be rest assured that if they litigate their grievances, at the end of the day, there can be some pronouncement by the court of law. And what these pronouncements do, generally speaking, is that they send a message to public officers that you can't act in any arbitrary manner. And if you do, the courts will call you out. If you do, your actions will be deemed unconstitutional and unlawful. And so that's a sort of bubble of excitement that I have, that other citizens can now come forward. I'm not saying that all our problems that we have in the judiciary have suddenly gone away. I am saying that if this trend continues, it would substantially help our democracy and embolden citizens to come forward, to hold leadership and power to account.
Speaking of this trend continuing, how do we use this as a precedent that we could build upon going forward, where the public can get to a point, like you put it, public officials accountable, so they don't just use their offices, take advantage of their offices without going through the right procedure. When generally though, it seems that a lot of people in Sierra Leone tend to either scare themselves away or shy away from, you know, going to the courts for several reasons. So how do we build upon this going forward to ensure that, yes, it becomes the trend and it gets public officials to pipe down on the excessive use of their authority?
Absolutely, Vivian, and I agree with you in terms of the lack of desire on the part of citizens to come forward, to access the courts. And partly that has been because the court was very reluctant to entertain human rights redresses in Sierra Leone. Because if you look at the constitutional history, in 2009, I know that the Sierra Leone Association of Journalists sought to litigate the freedom of expression. That case did not proceed on its merit. It was knocked out on technical grounds, as were many other cases before that. So the attitude of the court was pretty much, looking out for technicalities, throwing out matters on technical grounds. And I think there's been a significant shift, which I would describe as a paradigm shift, really, in terms of the attitude of the court. And I think what this does send out, more spectacularly, really, is that folks can now come forward. I'm not saying that because as I speak to you, I have a number of other matters in the Supreme Court which have not been listed for hearing. And my hope is that once those matters are listed, there'll be perhaps, such similar pronouncements on those matters. But I think that what citizens can build on generally on this is that there's no space that the hand of justice, that the hand of the court cannot reach. There's no person that the court cannot call out if their actions are excessive and if they fall beyond the limits of the law. To take such a person as the Inspector General of Police to court was such a monumental step. And because the IG is the head of the police, and the police is pretty much the implementer of executive policies and laws. So it's a very senior person in government. Okay. And once the Supreme Court has called that person out, I think there's no other person that the court cannot call out if their actions fall outside the limits of their authority.
Augustine, does this restore your confidence in the judicial system in the country? You're on record of, raising concerns on certain issues. This is the same Supreme Court that invited you, that summoned you, I think, the last time when you challenged certain judgments that they gave. Does this restore your trust and confidence in the judicial systems and processes in the country?
Amadou, I think it's a very important question, because I've been, perhaps the biggest critic of the judiciary in Sierra Leone. And, unless I'm mistaken, I don't think that suddenly all the problems in the judiciary have evaporated. To be honest with you, there are many challenges in the administration of justice. But like they say, Rome was not built in a day. I was not expecting a judgment in such a very strong term, to such an extent that the action of the IG was characterized as treason. And so while I would not say that my confidence has suddenly been restored, to be honest with you, but I think there's a glimmer of hope that if this trend continues, as I indicated in my statement, that if all the benchers would rise to the occasion, if they would seize this opportunity to continue this trail, we would rewrite a new story of the judiciary, and the judiciary would, basically restore its image and retake its place as the arbiter of a democracy. So my confidence has not been restored, but yes, there's a glimmer of hope. And my expectation and optimism is that this trend would continue, and that since the Supreme Court has handed such a very, very strong and landmark judgment, I've had conversations with other judges who sent messages of congratulations to me, And my encouragement to each one of them was that they should be inspired by this judgment, and they should dispense justice, noting that the Supreme Court seems to be on a new trajectory.
You mentioned about how this will get citizens to understand that, you know, they can go to the court and challenge decisions of state officials and people that they elect. And just a few days ago, we had Ibrahim Tomiya, who was talking about the government white paper, the constitutional review recommendations. And one of it that the government rejected is where citizens can take the government to court about right issues, say if they fail to provide better health care and education and all. In this instance, how could citizens better understand, you know, what matter they can challenge the government on, what matter they can take to court, and how the government itself is opening itself up to citizens to challenge them on critical issues as you've done?
I think the constitutional review process was a very monumental missed opportunity. You know, I was part of campaign for good governance position paper on some of the very tall omissions in that process. And it's sad that, you know, we spend, you know, billions of leons on that review process, and we could not get socioeconomic rights included in the proposed amended Constitution of Sierra Leone. I mean, all those recommendations, you know, citizens who participated in that process, they were in unison that socioeconomic rights should be included in the new Constitution of Sierra Leone. Unfortunately, when the government, you know, released the white paper, that very important clause has been rejected. And so, except for political rights, which are some of the rights that I litigated on, your rights to movement, you know, rights to protection from torture, et cetera, socioeconomic rights, which I think are very important in a very poor country like Sierra Leone, they should be added in a new constitution, because what they do is that they give that impetus, if you may, to citizens to come forward to say, we need better housing, we need better infrastructure, we need better planning in our communities. So when government rejects that, it sends a message that they are not prepared for serious business in terms of service delivery. So while I would note that that is a missed opportunity, I would continue to say that if you come to people like us who are scholars, we can always play around the Constitution to come before the courts, even on socioeconomic rights. Because in international human rights law, your right to life could be interpreted in such a manner that it would include your rights to health, your rights to food in several other jurisdictions. Say, for example, in India and South Africa, those rights have been broadly interpreted to include your rights to food, your rights to housing, et cetera, et cetera. So unless the courts were to expand the scope of understanding of these political rights, we could find a way to incorporate socioeconomic rights, even when they have been left out in the proposed new constitution.
Okay. Finally, is there any other matter we should expect you to take to the Supreme Court that is of importance to citizens of the country?
Thank you, Amadou. As a matter of fact, I have many, well, I have few matters. You would recall that when this government set up the Commission of Inquiry, the Bar Association, you know, they consulted me as their counsel to take a matter to the Supreme Court, you know, basically for a declaration that the lack of rules for the Commission of Inquiry, you know, was substantially undermined the process, and that the rules should be formulated by the Rules of Court Committee. That matter has not been listed for hearing. You would also recall that at some stage I filed a mandamus action against the Chief Justice. That application has not been listed for hearing. You would also recall that during COVID-19, when this government was passing throwing measures left, right, and center, I went to the Supreme Court to say that's not the way to, formulate measures and pass regulations. I filed that action in April 2020. It's now April 2022. It's 2 years on. That matter has not been listed. So I have a number of matters before the Supreme Court. And I know that we have this matter that we filed regarding the right to protest. It's been many years before the court equally. But those are the matters that are in the pipeline in the Supreme Court. But also, there's a very important matter which I've been briefed on, which has to do with delayed judgment. You would recall that many people have raised concerns about judgments that have been pending for God knows how long. Some people have been waiting for their judgment 5 years, 10 years, 15 years, many, many years. So I've had a client who was instructed me to take that matter to the Supreme Court, because there's a provision in the Constitution that once the court concludes on trial, that court is bound to deliver judgment within 90 days. But it seems that the attitude of the court is such that they keep judgment for eternity, and that should stop. And that's a very significant matter that I think that in the next couple of weeks, under a month, I would file before the Supreme Court. And if God willing, if there's the matter is listed, the court would hear me on that matter. And hopefully, I think that would, if there's a favorable outcome, that would give citizens the assurance that when they go to court, their judgment will be handed them within time, and that they would not have to wait until they go gray years for judgment to be delivered.
And lastly, just before we let you go, the concern about excluding the part where citizens can, have the opportunity to sue the government for lack of services on the white paper. Is that something you would be challenging?
It's very difficult because I have always I wrote a piece about the fact that what the government did was to reject recommendations from the people of Sierra Leone. I know of no constitutional procedure that sanctions that behavior, that they would sit somewhere in some office, in some air-conditioned office, and would be rejecting recommendations that have been put together by the people of Sierra Leone. More than 1,000 people, came together, put together recommendations, and some group of people sat somewhere, and they were rejecting them as if they were gods of this earth. It's something that we certainly, working with some few folks across the globe, that we are looking at and possibly, but as always, I would always say that there should be the political will. I mean, litigation does not solve all of our problems. If government does the right thing, citizens would not hurry to court to get them to do the right thing. And so my first approach would be to engage, which I think that many other players, I know that Ilraj, that Mrs. Michael runs, for example, they have done some piece on that. Campaign for Good Governance, for example, I know that Ibrahim Tomis Carl also, our collective call is that we must, in the 21st century, have socio-economic rights included in the Constitution of Sierra Leone. There is no point in having a new amended constitution without socio-economic rights. It means that we have not constitutionally evolved, we have not progressed at all, and it would be a significant waste of resources that we have a new constitution with socio-economic rights omitted. Put them in the constitution, and citizens can take that opportunity to take their leaders to court if their drainages are faulty, if their pipelines are not working properly, if electricity is irregular, they can take the government to court. And the fear of this government, and the fear of government generally, is that they think that when socio-economic rights are made justiciable in Constitution, there will be a number of litigations against them. Well, just do the right thing. If you do the right thing, citizens would not hurry to court to have their rights enforced against government.
All right, thank you very much for your time to join the program this morning. We appreciate your time.
Thank you too.